Elizabeth Musoke to deliver her judgment. You will please bear with her. I think she's got a little cold, so she needs your patience and understanding, my lord.
I hope you hear me. My voice is a bit coarse, but this is a summary of my judgment. The judgment will be provided as the leader of this panel, the head of the panel will advise. The appeal and cross appeal in this case against the decision dated 1st July 2021, rendered by the Constitutional Court. The quorum of Kakuru, Obura, Madrama, Musota, and Kasule acting judges of the Constitutional Court. That is Michael Kabaziguruka, Honorable, versus Attorney General. The Attorney General is the appellant, stroke cross respondent, and Honorable Kabaziguruka is the respondent cross appellant, stroke cross appellant. The particulars relating to the declarations and orders sought in the respondent's petition, the issues identified for determination by the Constitutional Court and its decision on those issues, as well as grounds of appeal and those of the cross appeal, have been set out in detail in the judgment of the Honorable the Chief Justice, which I've had the opportunity to read in draft. I also had the opportunity to read the draft the judgment of the judgment of Mugenyi, Justice of the Supreme Court. And in the interests of brevity, I'll straight away go into a discussion of the findings in my judgment. However, before giving my views, I should say that when the respondent filed his petition on 17th November 2016, he was challenging certain provisions of the UPDF Act of 2005. Under the 2023 revised edition of the laws, where the UPDF Act is now Cap 330, the numbering of many of the impugned provisions has changed, as indicated in the judgment of the Honorable the Chief Justice. Nonetheless, in this judgment, I make reference to the numbering of the relevant provisions as set out in the respondent's petition and the judgment of the Constitutional Court. Although for future purposes, the numbering contained in the revised Act should apply. My judgment, and I said I'm giving a brief, a summary of it. As I have indicated in my judgment, which you'll get, the grounds of appeal and cross appeal, in my view, raise the following questions for this court's determination. Whether the 1995 Constitution places limits on the jurisdiction that Parliament can confer on the General Court Martial and the other military courts, and if so, what is the scope of those limits? whether the jurisdiction conferred on the General Court Martial and other military courts under the UPDF Act goes beyond the applicable constitutional limits. Whether the General Court Martial is a subordinate court within the meaning of Article 129(1)(d). Whether the General Court Martial had jurisdiction to conduct the arraignment of the respondent, and if so, whether the arraignment contravened the respondent's right to a fair trial. Whether the General Court Martial and other military courts lack the capacity to render a fair trial, which is a non-derogable right guaranteed under Articles 28(1) and 44C. And lastly, what are the appropriate remedies to grant in this case? My perspective on these questions is as follows. The first question being regarding the limits under the 1995 Constitution on the jurisdiction of the military courts. I find that the military courts are established as military organs of the UPDF under Article 2010A, and that the 1995 Constitution under Article 2010B limits the jurisdiction that Parliament may confer on any military court to only matters falling within the sphere of discipline and removal of members of the UPDF. This implies that the nature of cases that may be tried by the military courts are limited to disciplinary offenses committed by members of the UPDF, and the nature of punishment that can be imposed for such offenses is limited to the disciplinary sanctions, which are also provided, which are dismissal with disgrace, reduction in rank, forfeiture of seniority, suspension, severe reprimand, and caution. So for the analysis of the first question, you'll find that analysis on pages 2 to 10 of my judgment. Second question, in relation to the second question of whether the jurisdiction conferred on the General Court Martial and other military courts under the UPDF Act goes beyond any applicable constitutional limits, I find that it does in many respects as follows. First, in respect of Section 2 and Section 119(1)(a) to F of the UPDF Act, which confer jurisdiction on the General Court Martial and other military courts to try members of the UPDF for offenses under Part 6 of the UPDF Act. The jurisdiction goes beyond the sphere of discipline and removal of members of the UPDF within the meaning of Article 2010B, insofar as the punishments prescribed for Part 6 offenses are not only limited to discipline sanctions, the only punishments that can be imposed by military courts under 2010, but include serious punishments like the imprisonment and the death sentence. Second, in respect of Section 2 and Section 179, which confers jurisdiction on the General Court Martial and other military courts to try members of the UPDF for offenses under the Penal Code Act and other enactments, the jurisdiction also goes beyond the sphere of discipline and removal of members of the UPDF within the meaning of Article 2010B, in that punishments prescribed under the relevant laws are not limited to only disciplinary sanctions, the only punishments that can be imposed by the military courts under Article 2010. But they include serious punishments like imprisonment and death sentence, as I said. Thirdly, in relation to Section 2 and Section 1191G, which confer jurisdiction on the General Court Martial and other military courts to try non-members of the UPDF who are alleged to have aided and abetted members of the UPDF in commission of Part 6 offenses. The jurisdiction goes beyond the sphere of discipline and removal of members of the UPDF within the meaning of Article 2010B, in that the category of persons covered by this jurisdiction are not members of the UPDF, in respect of whom Article 210B was intended to cover. In addition, as with the first two categories, the jurisdiction goes beyond the sphere of discipline and removal of members of the UPDF because the prescribed punishments for Part 6 offenses, which include the imprisonment and death, are more severe than the disciplinary sanctions which can be meted by the military courts under Article 2010B. Fourthly, with respect to Section 1191H, which grants jurisdiction to the General Court Martial and other military courts to try non-members of the UPDF who are found in possession of proscribed military equipment, this jurisdiction also goes beyond the sphere of discipline and removal of the UPDF, members of the UPDF, for three reasons. First, the persons affected are not members of the UPDF who fall within the jurisdiction of the military courts. Secondly, Section 1191H appears to be a penal provision, but it does not prescribe a punishment. And thirdly, the punishment for analogous offenses under other laws include terms of imprisonment, which fall outside the nature of punishments that can be imposed by the military courts under Article 210B, which are limited to disciplinary sanctions. In light of these observations, I find that Section 2, Section 1191A to H, and Section 179 all grant jurisdiction to the General Court Martial and other military courts, which is inconsistent with Article 209A and 210B, and therefore, to the extent explained, unconstitutional and null and void. For the fourth category, which is provided for under Section 1191H of the UPDF Act, I find that it does not fall under the sphere of discipline of the UPDF, as it is neither concerned with members of the UPDF nor with disciplinary sanctions that can be given to members of the UPDF for engaging in unacceptable conduct. For the analysis of the above second question will be found on page 10 to 15 of my judgment. The third question, it's with respect to the question of whether the General Court Martial is a subordinate court. I note that Parliament is required to enact legislation under Article 129(1)(d) for the creation of a subordinate court. But for the General Court Martial, Parliament moved under Article 210B with an intention to create a disciplinary body for the UPDF, not a subordinate court. I also find that, in any case, going by the provisions of Article 210B, the framers intended that military courts could only be established as disciplinary organs of the UPDF and could not be vested with a general judicial function so as to leave room for their establishment as subordinate courts. In addition, I find that a court can only qualify to be called a subordinate court if it's subject to the supervision of a superior court through revision proceedings. I note that the General Court Martial is not subject to the supervision of any of the superior courts under Article 129(1), including the High Court, Court of Appeal, or Supreme Court. And I conclude that on this account alone, cannot be stated that the in my view, that the General Court Martial is a subordinate court. I also find that it's not a subordinate court because it lacks essential features found in other courts of judicature, such as competence of its officers as legal professionals and lack of independence and impartiality. With all due respect, I propose the overruling of the dictum of Mulenga UGSC in this court's decisions in Attorney General versus Joseph Tumushabe and Attorney General versus Uganda Law Society. Citations are given, in which Mulenga UGSC expressed the view that the General Court Martial is a subordinate court within the meaning of Article 129D. Because in my view, that dictum was erroneous. I also point out that the Joseph Tumushabe case was concerned with the version of the GCM of the General Court Martial under the now repealed UPDF Statute number 3 of 1992, enacted before the coming into force of the 1995 Constitution, which makes it distinguishable since this appeal is concerned with the version created under the UPDF Act 2005. I therefore find that in the present case, this court does not have the same liberty to characterize the General Court Martial, since when Parliament enacted the UPDF Act, which provides for the current version of the General Court Martial, it could only establish a disciplinary body for the UPDF under Article 2010A and B. The third question, the analysis of the third question will be found on pages 15 to 19 of my judgment. Now the fourth question, regarding the constitutionality of the respondent's arraignment. I note that in light of the position taken in my judgment, that under Article 2010B of the 1995 Constitution, the General Court Martial is limited to hearing cases involving members of the UPDF. And I take the view that since the respondent was not a member of the UPDF at the relevant time, his arraignment was unconstitutional. For the analysis on the fourth question, see page 17 of my judgment. Fifth question, in relation to the fifth question, whether the General Court Martial and other military courts lack the capacity to render a fair trial, which is a non-derogable right guaranteed under Articles 28(1) and 44C, I express the view, in agreement with the views expressed in the respective judgments of the Honorable the Chief Justice and Mugenyi, Justice of the Supreme Court, that there exists several deficiencies in the setup and operations of the General Court Martial that diminish its capacity to properly adjudicate cases. And these include objective lack of independence of both the General Court Martial as a court and of its members as individuals. The lack of competence of the members due to their lack of legal training and knowledge, and the absence of effective mechanism for reviewing the correctness of the decisions of the GCM, of the General Court Martial. I note that our constitution was put in place to ensure a just, free, and democratic nation which encourages respect for people's fundamental rights, which was the reason for establishing the courts of judicature under Chapter 8 and vesting them with the mandate to exercise judicial functions fairly and do justice in all cases. I note that for criminal trials, the needs of justice require that accused persons are tried before competent courts or bodies that are capable of guaranteeing the right to a fair trial, and that, unfortunately, the deficiencies highlighted above render it impossible for an objective observer to conclude that the General Court Martial can guarantee the right to a fair trial. And as it is well known, a fair trial is a vital prerequisite for ensuring justice in criminal cases. I therefore find myself in complete agreement with the analysis and views of the Honorable Chief Justice and Genyi UGSC on the deficiencies in the General Court Martial and how they render it incapable to accord a fair trial to the people that fall within its jurisdiction. In light of the highlighted deficiencies, I express the view that it is necessary not only to give a strained construction of the matters that properly fall within the ambits of discipline and removal of members of the UPDF, but also to ensure that as far as possible, offenses are tried by courts of judicature, not military courts. I further express the view that it is, therefore, inappropriate to grant the military court's jurisdiction beyond the trial of members of the UPDF for disciplinary offenses under Part 6 and the imposition of disciplinary sanctions as punishment for those guilty of disciplinary offenses. All other criminal matters ought to be handled by courts of judicature. However, even in cases involving disciplinary offenses under Part 6, there should be established a mechanism providing for revision of the decisions of military courts by the courts of judicature to ensure that the ends of justice are met. In my judgment, I exhort the learned Attorney General to take interest in the best practices set out in the respective judgments of the Honorable the Chief Justice and Mugenyi UGSC, which represent the best reforms to improve the military court system. These are found on pages 19 to 20 of my judgment. In conclusion, and for the reasons given in my judgment, which you'll get, I would disallow all grounds of appeal and allow the sole ground of cross appeal. I would make I'll take on the declarations numbers 4, 5, 6, 7, and 9, and orders 1, 2, 3, 4, 5, and 7 contained in the judgment of the Honorable the Chief Justice, since they are consistent with the findings in my judgment. I would also commend the Honorable Chief Justice's advisory orders to the attention of the learned Attorney General. I would then make the following separate declarations arising from the findings in this judgment, in addition to the ones I have pointed out above contained in the judgment of the Honorable the Chief Justice. Number 1, General Court Martial is not a subordinate court within the meaning of Article 129(1)(d) of the 1995 Constitution. General Court Martial and other military courts are disciplinary organs of the UPDF established under Article 210, whose jurisdiction is limited by Article 210B to handling matters related to discipline and removal of members of UPDF, including formal and assimilated members of the UPDF, as stipulated under Section 1191A to F of the Act. Number 3, the jurisdiction of the General Court Martial and other military courts is under 210B, limited to hearing matters involving disciplinary offences under Part 6 of the UPDF Act, committed by members of the UPDF as defined in paragraph B, and is also limited to the imposition of disciplinary sanctions to the members of the UPDF found guilty, as I have already stated. I enumerated the offense, the punishments earlier on. Jurisdiction of the General Court Martial and other military courts does not extend to hearing cases involving civilians who are neither formal or assimilated members of the UPDF, as defined in paragraph B. The hearing of cases involving civilian non-members of the UPDF falls within the jurisdiction of courts of judicature established under Chapter 8 of the 1995. The hearing of cases involving members of the UPDF, as defined in paragraph B above, for the commission of offences under Part 6 of the Act, and where it is appropriate to impose a sentence of imprisonment or a more serious sentence, falls within the jurisdiction of courts of judicature established under Chapter 8. The hearing of cases involving members of the UPDF, as defined in paragraph B above, for the commission of general civilian offences created under any enactment other than Part 6 of the UPDF Act, falls within the jurisdiction of the courts of judicature established under Chapter 8, the Constitution. Section 2, 1191H and G, and Section 179 of the UPDF Act, in as far as they confer jurisdiction on the court martial and other military courts to the constitutional limits, contrary to the constitutional limits described above in this judgment, are unconstitutional and null and void. I would make the following orders, in addition to the ones which I adopt from the Honorable the Chief Justice, which are in his judgment orders, in the draft judgment which I read. There were orders 1, 2, 3, 4, 5, and 7. I would just add that going forward, only cases involving members of the UPDF and related to disciplinary offences under Part 4 of the UPDF Act should be tried by the General Court Martial and other military courts, and that only the disciplinary sanctions as described at C above can be imposed by the military courts in those cases. Number 2, where a military court determines that the imposition of a more serious punishment, such as imprisonment or the death sentence, is necessary, in addition to removal from service, the military court shall forward the case filed to the Director of Public Prosecutions with a recommendation for institution of criminal proceedings in a competent court of judicature. I'll adopt the order made by the Chief Justice on the respective effect of, or otherwise, of this judgment. Otherwise, I would award costs of the appeal and the cross appeal in this court and the costs in the Constitutional Court to the respondent.